Proportionality when it comes to self-defense cases. So, self-defense is one of the most often used defenses in the state of Indiana. It's an absolute defense to a crime that had occurred. Now, we have a ton of videos on self-defense, but the main takeaways for self-defense is you have to be in a place where you're allowed to be, number one. You have to act reasonably, both in the eyes of yourself, so subjective reasonably, and objective reasonably. In other words, what would other members of society feel in the exact same situation? So there's kind of a three-pronged test that people look at when it comes to self-defense cases. Now, for self-defense to apply, you cannot be the initial aggressor. In other words, you can't just go up to someone in a bar, throw a drink at them. You can't go, hit them in the face or anything like that. Self-defense is going to be invalidated there. You also cannot be in the middle of committing a crime. In other words, you can't be, let's use theft for an example, right? So let's say you're in a Target, you're in a Walmart, and you're trying to take something. If someone approaches you, hey, you can't do that, you can't then turn around and punch that person in the face. That's not self-defense, because you're actually in the process of committing a crime, that being theft. So when it comes to self-defense, you have to both be acting reasonably in the eyes of yourself, so you had to have felt danger, felt scared, you would have had to have believed that perhaps there was going to be some type of action taken against you that was going to put your life or your liberties at risk before you can act. And then again, you cannot be the initial aggressor. Now, when it comes to proportionality in self-defense, what does that mean? Well, proportionality basically means you can't exceed the force that's used against you. In other words, if someone comes up at you angrily in a fighting situation with no weapons or anything, you might fear they're going to push you, you might fear they're going to punch you. You have every right to punch that person. If you feel scared, they approach you, they're yelling at you, they're getting in your face, absolutely. You absolutely can act in self-defense in that case. But what can't you do? Person's yelling at you, screaming at you, wailing their hands, even comes up, might even try to wind up a punch. You can't then just pull out a weapon and shoot that person. Self-defense is gone at that point. So when it comes to proportionality, there has to actually be, you have to be acting in force reasonable and about the same level. So you can't take it up a notch, right? Excessive force, basically that situation where someone's coming at you, maybe verbally assaulting you, being mean, yelling at you, getting in your face, maybe even squaring you up like he's going to fight you, pulling out a weapon, bam, that's excessive force. Immediately invalidates a self-defense claim. If you take it up a notch, if you then were to be in a situation where the force that you use is greater than the force you feared was going to be used against you, boom, self-defense is out the window. You can no longer use that defense. So when it comes to proportionality, the courts and the jury, because the jury is ultimately the finder of fact, has to make the determination as to whether or not you acted reasonably in that situation. Now, when is deadly force available for use in a self-defense claim? Someone comes at you charging with a knife, a weapon, a baseball bat. You want to go old school? You can go ball and chain, whatever you want. If someone comes and points a weapon, absolutely fire away. At that point, you are using the exact same amount of force that you fear is going to be used against you in that situation. So if deadly force is being threatened or even perhaps advanced upon, you are well within your rights to meet deadly force with deadly force. That's kind of that proportionality issue. As long as the force matches or is slightly below, then you're okay in the eyes of the law when it comes to self-defense. So self-defense can be very tricky, but once you raise it as somebody charged with a crime, the state then has to disprove that defense. In other words, if you just say, hey, I acted in self-defense, I was where I was supposed to be, I wasn't committing a crime, I didn't take it up a notch, right? Or hey, I used deadly force because he had a weapon pointed at my face. I was scared for my life, I was scared for my kid's life, whatever it may be, you can then use that deadly force in response. So if you raise that, the state must then come up and say, hey, I understand they raise self-defense, but here's why self-defense doesn't apply. Then they have to disprove whether or not self-defense can apply in that particular situation. So again, when it comes to self-defense, you cannot be the initial aggressor. If you end up in a tussle, you have to then retreat, and kind of withdraw from the situation. So basically, if you are an initial aggressor, you can't use self-defense for the first one, but if they come, if you're leaving, you're walking away, and then they come back again, then you can use self-defense. So you might be looking at a double charge situation, sure, but in that particular situation, because you disengage from the original act, everything subsequent to that you're not the aggressor for, you're going to be okay. So when it comes to self-defense, things can get a little bit convoluted. But again, it is the number one defense in the state of Indiana. So if you find yourself charged with a crime, you find yourself in a situation where you have to defend yourself, where you have to defend someone else, give us a call. Self-defense can be a little bit tricky. 317-632-3642, and remember, always plead the fifth.